Good morning, everyone, or at least good morning to everybody in Australia and your relative time zones. Welcome. My name is Dr. Michelle Maloney. I'm the National Convener and co-founder of the Australian Earth Laws Alliance. And I am really delighted to be co-hosting this event today with Mari Margol and Alice Gorman. We'll introduce them in a moment. The topic of our talk tonight, which is in the screen behind me, is Should the Moon Have Legal Rights? And we're delighted to be joined by Eitan Tepa, Cassandra Steer, and my wonderful colleagues Mari and Alice, who together with Thomas Gooch, we crafted the Declaration for the Rights of the Moon, which we'll talk about towards the end of our presentations today. Firstly, it's an important tradition in Australia to acknowledge country. I'm a descendant of the people who were brought to this beautiful continent as part of the colonisation project. So I'd like to acknowledge that I live, work and play on the unceded lands of the Turrbal and Yagara peoples in North Brisbane. I'd like to acknowledge elders past and present and the emerging young people and leaders who are continuing culture. The Indigenous peoples of this continent are some of the oldest continuous cultural groups in the world, and it is quite a remarkable privilege to be living in a continent that has been cared for such a long time. And the relationship of Indigenous peoples to the moon is also ancient, and we'll talk a lot about our beautiful moon in a moment. So I'd like to acknowledge country and acknowledge the role that all of us play in decolonising our thinking, our minds, our hearts, and caring for place and caring for our cosmic neighbours, which brings me to our session today. The Australian Earth Laws Alliance was created about 10 years ago by a group of lawyers concerned about the role that law plays in continuing the destruction of the living world. Within our first year or two, we became quite multidisciplinary. We're very interested in how we create systems change from a human-centred, growth-focused, industrialised world to something much more earth-centred and caring for the living world. AELA is inspired by two key branches of thinking. One is earth jurisprudence, which we often think of as Westerners looking back at their own Western culture through the lens of Thomas Berry and some of his work, but also, and particularly in Australia, inspired by Indigenous thinking and Indigenous knowledge systems. And within our work, within AELA, we care about place, we care about the planet, we work at the tiny molecular level down on the ground, but we're also deeply concerned about what the plans are by humanity for our beautiful neighbour, our ancient evolutionary companion, the silvery shiny moon. So it's with that in context that last year we hosted our first week of webinars looking at space exploration, and we'll be doing it again this year. We titled it Space Exploration, an Update for Earthlings. And we were delighted to have some amazing speakers over 3 or 4 days with different time zones talking about what's going on in space exploration. Today's event was really the brainchild of Alice Gorman, who I can't wait to introduce and hear speak again, because today is officially Yuri's Night, or the proper title, which I can never remember all of it, is the International Day of Human Flight. And I might let Alice talk about that a little bit more. So thank you for letting me do an introduction. And if you're interested in the work of AELA or any of these other organisations today, we'll pop some notes into the chat. Our speakers will be, Alice will give an introduction to what humanity's alleged plans are for the moon and beyond. And then we'll go to Cassandra Steer, who we're really grateful she's made time to be with us today. She's actually at a very interesting conference, which I hope she'll tell you more about. Cassandra is the Deputy Director of the Australian National University Institute for Space. And then we'll be joined by Dr. Eitan Tepa, who's a visiting assistant professor and director of the Space Governance Lab at Indiana University, Bloomington. And his qualifications, as Cassandra's are on our event details. So we're aiming for 30 minutes Q&A at the end of our presentations today. So if you've got any questions, please write them in the chat at any time. Otherwise, please stay on mute and enjoy this remarkable conversation. Alice, over to you, Ms. Gorman.
Thank you, Michelle. I'm really excited that we're having this important discussion on an auspicious day because, as mentioned, 12th of April is known internationally as the International Day of Human Spaceflight, or Yuri's Night. And this is the anniversary of Yuri Gagarin's epic first orbit of Earth. He was the first person to leave Earth, to go outside Earth, and he survived. So this is one of the key moments in the development of human endeavours in space. So I want to give a little bit of background to what's happening on the moon. A couple of years ago, it was the 50th anniversary of the Apollo 11 landing at Tranquility Base. And as many people remarked, 50 years elapsed with nothing more than scientific missions, ongoing missions like the Lunar Reconnaissance Orbiter and laser ranging to various reflectors on the moon. And with a change in direction for space agencies and space industry across the world, with a greater emphasis on public and private partnerships and the growth of private space corporations, the focus changed. And discussions started to happen about the resources that the moon had, which might offer something for Earth. People proposed that moving mining off Earth onto the moon would actually have environmental benefits for Earth, and the resources that the moon could provide for going on to Mars started to be discussed. So over the last decade, you would often go to some kind of space meeting and people would ask the question, moon or Mars? And there would be debates about whether we should be throwing all our technological and financial resources at getting to Mars, or whether we should start with the moon, go back to the moon and learn more about it and what it can tell us about our place in the solar system before going further into the solar system. Maybe, I don't know, maybe about 5 years ago, those debates changed radically in nature. It was no longer moon or Mars, it was moon and Mars. Particularly the resources, and I do keep using that word resources, but that in fact is something that we should be debating as well. These included things like water ice, which numerous missions had confirmed was present in the lunar North and South Pole in regions known as the permanently shadowed regions. In deep, cold craters, it was proved that water ice existed. And you might think the first use for water ice is to enable humans to drink something when they establish some kind of habitat on the moon. But in fact, water ice can be used to make rocket fuel, and that rocket fuel can be used to support a local lunar economy and to manufacture fuel to go onto Mars. So the weight of carrying all these resources from Earth would be halved or even further. And there are also suggestions that the moon has resources such as helium-3, which could be used as a clean energy source. This has been tested at small scale on Earth, but we don't actually yet have the technology to use it to produce energy in anything like the quantities needed. And rare earth elements, which are an essential component in the electronics manufacturing industry and many others. So the moon suddenly became of interest as a source of materials that could be put to numerous uses. And most of the focus became on the permanently shadowed regions, particularly at the lunar South Pole. And this is where people are throwing their efforts at the moment. Now, these permanently shadowed regions to me are fascinating. So because of the angle of the moon and the depth of some of these craters, sunlight has not penetrated their depths. And I apologize for continuing to use this sort of terminology, for 2 billion years. There are shadows 2 billion years old at the lunar South Pole. And it's extraordinary for me to think about something as evanescent as a shadow actually having such permanence. Permanently shadowed regions are not a common feature of the solar system. We know of 2 others apart from the moon, on Mercury and on the planetoid Ceres in the asteroid belt. So it's a rare landscape type. But this is where everybody wants to go back. Not only do the permanent shadows trap and preserve the precious water ice, but they're balanced by what's called peaks of eternal light. So just as the permanently shadowed craters receive no sunlight, they do, however, receive starshine and zodiacal light and a number of other interesting kinds of light in the solar system. the peaks of eternal light are always in sunshine. So they're being recast as places where solar energy installations can be set up to power the ice mines that people are proposing. It's not likely that this form of mining will resemble the mining we know on Earth. Some of the proposals have included creating installations where the ice would be melted, the vapor then collected and then processed for further use. There are some big technical and environmental issues with attempting to extract lunar resources. So you have probably heard people talk about the importance of Australia's expertise in remote automated mining operations. And it's true, we do have that kind of expertise. However, machinery doesn't operate when it's in temperatures of minus 150 degrees in the same way that it does on Earth. The concept of drilling something is incredibly difficult. Human materials and geological materials don't behave in the same way at these kinds of temperatures. So while there is a lot of discussion about how we will extract these resources, there's also an incredible number of technological difficulties. However, the discussion continues and the number of lunar missions planned around extracting this water ice continues. So right at the moment, we have the Japanese iSpace Orbiter, which is planning to put a lander on the moon somewhere towards the end of April. The Artemis 2 mission is going to take a human crew and put it into lunar orbit, the first people who will have seen that view since the 1960s. And the Artemis 3 mission is planned to land in the permanently shadowed regions. There's a lot of excitement about Artemis 3 because they are going to give a woman an opportunity to step on the moon for the first time, and likely a person of color as well. So this is a breakthrough. This is exciting stuff, but there is still so much to be worked out. So international space organizations are very busy working around these concepts. The UN has produced long-term sustainability guidelines to guide future human activities in space. There's a set of principles known as the Hague Building Blocks, which is attempting to provide an ethical foundation for sustainable and ethical use of the moon, among other solar system bodies. And even more recently, we've had the Lunar Policy Handbook, which has just been released, and the Global Expert Group for Sustainable Lunar Activities, of which I am currently vice chair, presented its recommended framework and key elements for peaceful and sustainable use of the moon to the United Nations just a couple of weeks ago. The other document people are talking about is the Artemis Accords, which is a set of principles created by the United States that it is inviting its international partners to sign up to. Australia is a signatory, as well as numerous other nations. And this commits to peaceful use of the moon and also, which is of particular interest to me, the preservation of natural and cultural heritage on the moon. So there is a lot of consideration of what constitutes causing harm to the lunar environment. But there's also a very strong voice from the private and commercial lobby to either restrict these definitions to allow lunar resource extraction to go ahead, or to define them in such a way that mining isn't considered to be creating harm to the lunar environment. And it was partially in the context of this debate that a few of us, as Michelle has mentioned, created the Declaration of the Rights of the Moon. I think it would be fair to say that the current ethos around going back to the moon is hyper-capitalist. So the moon is considered to be a dead world with resources there for the use of humans, and without the pesky interference of Indigenous people or biotic ecologies. So the concept of harm to the moon is being considered as not such a big deal, really. in this context, when we created the Declaration of the Rights of the Moon, we were aiming to pull the dialogue back towards the centre a bit, I guess. We wanted to create something to balance these extreme hyper-capitalist views and, as Michelle said, create something that we can start different kinds of discussions around. So I think that is enough of an introduction here. And I will pass back to Michelle for the next part of our webinar.
Thank you so much, Alice. That was really a very, very important and wonderfully succinct 10-minute overview of all of the activities that are going on. And can I say that as a general citizen interested in caring for our cosmic neighbours, I was very surprised over the last few years when I came across all the material about what's going on with plans for the Moon and Mars. Many of the conversations are as if it was already happening. Others are saying it won't be for decades. But either way, more of humanity needs to be involved in these conversations. So thank you so much, Alice. I'm now bringing the spotlight onto Cassandra. Cassandra, thank you so much for joining us. I'll hand over to you. And please do mention the really fascinating conference that you and Alice are both attending today as well. It's very exciting. Thank you.
Thank you so much, and thanks for the invitation to be part of this. So I'm coming to you from Ngunnawal country in Australia's capital, and I also acknowledge and pay my respects to elders past and present. And I also think that the ongoing continuing connection to country, and that includes to sky country, that our Indigenous peoples have in Australia have a lot to teach us about sustainable and intergenerational management of difficult environments. Which is highly relevant to what we're talking about today. So briefly, the conference that Michelle keeps alluding to, the Australian National University Institute for Space, where I'm the Deputy Director, together with the Australian Centre for Space Governance, of which I'm the Chair, we have collaborated with the Global Institute for Women's Leadership, which is an institute set up by Julia Gillard a few years ago, and to put on this conference, a national conference on diversity at the frontier. So it's not only about gender equality and gendered perspectives on the space sector, but it's also taking an intersectional perspective. So we have a panel looking at First Nations perspectives. We have a panel about the Women, Peace and Security agenda, which is about the need to increase women's participation and bring a gendered perspective to conflict scenarios and how that should apply to space security. We have various different generations represented amongst our panelists. And different ethnicities as well. So really taking an intersectional approach. And it's a a day-long conference tomorrow with some workshops either side. So I think what we're doing is really kicking off the discussion in Australia, which is already starting to happen in other parts of the world. But what I wanted to focus on today, what I was invited to focus on today is, and I'm just going to play with my screen a bit because I have some slides here, whether the moon should have legal rights, or I've said, or international law meets the moon. So the starting point really for international space law is the 1967 Outer Space Treaty. And I often describe that as a constitution for space activities. And that's because it is a treaty that has principles and not specific regulations. This is not about regulating specific activities. It doesn't go into enormous detail. Some people at its 50th anniversary a few years ago started to call for replacing it or opening it up for negotiation because it's no longer fit for purpose. And I fundamentally disagree with that narrative or that question every time it's raised, because it acts as a constitution. We don't change our national constitutions every time there's new technologies or new social issues. The Constitution is really designed to be a set of general principles, organizing principles and values around which we operate. And then when there are new activities or new technologies or new societal issues, we come up with lower level regulations, which are much easier to change, legislation and so on. And so the treaty still is fit for purpose because it carries those general principles. And it's about regulating human activities in space. So the giggle factor, I think, sometimes arises, oh, if you're a space lawyer, you must be talking about treaties with aliens, but it really is about regulating our human activities in outer space. And the core principles that I want to highlight here are in Article 1, that every state has the right of access to and use of space, And that goes for all nations, and it highlights regardless of the status of economic development of any nation. So without discrimination, and all space activities are to be for the benefit of all mankind or humankind, if we're to update that language. It might sound very lofty and aspirational, but it really was because this was the height of the Cold War. The Soviets and the Americans had both tested all kinds of nuclear weapons and other kinds of weapons in space. And they very quickly became conscious of the fact that if they wanted to continue to access this new technological domain, they would need to come up with some shared principles that restrained each other. And a lot of the middle powers of the time, and also remembering that in the 1960s, there was a huge wave of decolonization. Countries, particularly in the Asia and the Pacific, some parts of Europe, were decolonizing from prior empires' colonizations. And those smaller and emerging nations also were very keen to see the right of access for all nations enshrined in the treaty. So one of the key principles when we're thinking about everything that Alice just talked us through, and this new race to the moon, because the Outer Space Treaty and the other early space treaties were all in the context of the geopolitical race to the moon between the Soviets and the Americans. Of course, whoever was going to be the first to plant their flag on the moon was going to be able to declare some kind of win in the Cold War. Today, what we're seeing is a new race to the moon for resources, and that is both geopolitical and, as Alice said, hyper-capitalist, so highly commercialized. But one of the principles enshrined in the Outer Space Treaty is that there is no national appropriation. So when the US planted its flag on the moon, it was merely symbolic. No national appropriation by claims of sovereignty, nor by any other means of any celestial body, so any natural body that in space can't be owned by a state. What we're seeing is that this is being put under pressure if we're talking about resource extraction. And different countries have started to interpret this particular principle in their domestic legislation. So the US in 2015 already put in place, a commercial space law act, which said that it interprets this provision of the Outer Space Treaty to allow resource extraction, because that is not appropriation. Not only that, that law says that the US will protect the rights of any US person, which includes private commercial entities, to extract, to change, to process, and to sell resources that they manage to extract through their own efforts in space. And they don't see that as appropriation. I think if you speak to any nation that has had foreign countries or foreign companies come in and mine and extract their oil or their fishing or their natural resources on the land, that very clearly is appropriation. But there are debates around how to interpret this. The Outer Space Treaty also says that every single activity in outer space must be in accordance with international law. And the most important thing about that is that it prohibits use of force and other key principles of the UN Charter, and encourages peaceful and pacific resolution of any disputes. It also prohibits in Article 4 the placement of military bases on the moon or any other celestial body, but it doesn't prevent military personnel from taking part in scientific activities. And that's logical also, particularly in the 1960s, only military personnel could be selected into astronaut programs to become astronauts. Today, in the US in particular, and also in Russia and China, many astronauts have military backgrounds, though that's becoming less the case. But military bases themselves are prohibited. Article 6 is a very important article and a very clever article, because what it does is it says states remain responsible for all national space activities that fall under their jurisdiction, whether those are governmental or non-governmental, i.e. commercial. So something that SpaceX does, the US is responsible for under international law. Last year in Australia, we had large amounts of, or large pieces of debris that belonged to SpaceX landing on some farmland in New South Wales. Because Australia and the US are quite friendly nations, and thankfully because there was no damage either to livestock or to property or to humans, that was resolved very quickly and very easily. But had there been some damage, Australia would have been able to hold the US responsible, and the US would have then gone back to SpaceX to recover any costs. So that article also says that states are obliged to authorize and continually supervise all of those space activities. What that means is states have to put in place a national legislation and licensing requirements and permits and insurance requirements and safety requirements and assessments and environmental assessments of activities. And so there is, in fact, an enormous amount of law and regulation governing space activities. Most of it is at the domestic level. And then Article 9 says that any activities a state is undertaking in space where they think that there may be potential for causing harmful interference with other activities of other states, they have to act with due regard. They have to consult or at least let other states know. It seems like a soft obligation. In fact, it's been breached a few times when states have tested anti-satellite weapons. So China, the US, India, and Russia have all tested shooting a missile at one of their own satellites and destroying it and creating debris. Because we know those activities create debris, in each and every one of those cases, those states should have consulted. They should have notified other states. They're about to undertake something that could have harmful consequences, and none of them did. But what we haven't seen is any desire on states to enforce anything about the breach of that article. So everything still comes down to political will. That doesn't undermine the legality or normativity of the treaty. What it says is something about the political relationships between states and whether they're willing to do something about a breach at any given moment. So that's the Constitution. There are 5 key space treaties. The only other one I'm going to talk about today is the Moon Agreement. The Outer Space Treaty has about 112 countries that have signed up to it, including many smaller nations. The Moon Agreement, 1979, has today 17 signatories. So it never got buy-in from the major space actors, the US, China, Russia. None of those countries have ever signed on. It did have 18 signatories up until last year when Saudi Arabia withdrew its signatory and ceased to be a party. And that has to do with the Artemis Accords, which I'll speak to a little bit more in a moment. But the 1979 Moon Agreement was really smaller nations who were concerned for the potential for larger nations in particular to go and do what we're about to see happening, which I think the new race to the moon is going to see early space mining activities happening in the next 5 years. And in 1979, there were already concerns for whether this may start to take place either on the part of states or potentially with involvement of commercial entities. So we think about commercialization of space as mostly being a 21st century phenomenon from the early 2000s, but they were already starting to see, for instance, TV broadcasting was very much commercialized right from the beginning. So there were already concerns about the role commercial companies might play in those activities. So the Moon Agreement is all about equitable access but also distribution of what might come out of those activities. So not only does it underscore that shared benefits and benefit of all humankind that's in the Outer Space Treaty, it takes it a step further. And that's one of the reasons why the major spacefaring nations never bought into it. So there's a lot of text to this. I'm just going to zoom in a bit. The preamble of a treaty is never binding, but it does indicate the object and purpose of the treaty, why that treaty is in place. And it states that the parties desire to prevent the moon from becoming an area of international conflict because they can see the potential for that happening in the future. And also bearing in mind the benefits which may be derived from the exploitation of natural resources of the moon and other celestial bodies. So the core principles, and again, I'll zoom into that. I won't go into them into too much detail, but they do highlight again some of the principles of the Outer Space Treaty, that activities must be exclusively for peaceful purposes. You can't do this to wage a war, and the applicability of the UN Charter. It highlights not only the benefit and interests of all countries, but for the first time, it makes explicit that intergenerational equity has to be taken into account. So if we are going to be mining the moon for resources, what are we going to do about ensuring that those resources are ongoingly accessible for future generations? And also that the moon can be preserved for future generations. There is freedom of scientific investigation. So that means, yes, you can go and extract lunar regolith for scientific purposes to study it, to understand the moon. But that's an attempt to try and, reduce the commercial activities or the commercial profit-making activities of resource extraction on the moon. It also puts in place an environmental law principle called the precautionary principle, which obliges states party, and again, there are now only 17 countries obliged to follow this, take measures to prevent the disruption of the existing balance of the moon's environment or any celestial body. So this would also apply to mining on asteroids. So there are some international environmental law principles which would apply to any space activities as a result of Article 3 of the Outer Space Treaty. which says that everything has to be in accordance with international law. But this Moon Agreement tries to make those things more explicit. The most important article, I think, for our purposes today is Article 11, which states that the moon is the common heritage of all mankind. So that actually goes a step further than the Outer Space Treaty, which says the province of mankind. The common heritage of mankind comes from the laws of the sea. It brings with it an assumption that probably means that any resource extraction, whether that's oil or fish or resources on the moon, should lead to some kind of benefit distribution. So there is an attempt under the law of the sea and the Deep Seabed Mining Authority to require states to pay into a kind of shared fund from any benefits they derive from mining from an area that's beyond national jurisdiction. And those benefits would then be redistributed equally across other countries and other parties. The US, for example, has made absolutely explicit it wants no part in any such regime, whether that's for the law of the sea, the deep seabed, or for the moon. And other countries have taken a similar stance. But the Moon Agreement says there is no national appropriation, and it says no part of the moon can become the property of any entity. So that includes commercial entities. The thing I love about this is that when we link that with the fact that the US has decided to call its program the Artemis program. Artemis, of course, is the twin sister of Apollo, which is why they chose the name, because the Apollo missions is what first took them to the moon. She's also the goddess of the moon. And in the Greek mythology, she actually said to her father Zeus, I don't want to wear a long dress. I need a short one so I can run and hunt. I want to be independent. And I never want to marry because I never want to become the property of another man. And here we have the Artemis program returning to the Moon Agreement saying no part of the moon can belong to any entity. It's the common heritage of mankind. And yet the Artemis Accords, which I will say briefly a couple of words about, is stating that mining the moon and appropriating the moon is possible. So there's a bit of contention even around the mythological character they've chosen to name that particular mission or that program. The other thing about this article is it obliges states party to establish some kind of international regime to regulate these activities at such a time as the technology is about to become feasible. So Australia is a party to the Artemis Accords. I have actually argued to our Department of Foreign Affairs and Trade and our Office of International Law, Attorney General's Department, that we are obliged to trigger this article, this particular part of the article, because this technology is about to become feasible. And we actually have a huge opportunity in Australia to take some kind of leadership in this. But we do find ourselves in a bit of a tense position. So Alice mentioned the Artemis Accords, the Artemis mission, of course. Everybody is quite excited about the focus on diversity in the Artemis crews. But the Artemis Accords were very much written by US lawyers in the State Department. And I've spoken at length with the person in particular who really was responsible for the early drafting of this, his stance is that this is really about advancing peaceful purposes, ensuring that states can work together. He really has a great starting perspective. But in my discussions with him, he has indeed, I think, accepted the fact that it is also about ensuring that it's US first, right? So the narrative of the US being able to be the prime actor again, the way it was in the early, the 20th century space race. It's a non-binding set of principles. It was made explicit right from the start. It is not a treaty. Originally, it was set up as a series of bilateral agreements between the US and each of the countries that wanted to partner on becoming part of the Artemis program. And so it kind of forced the hand of states to make a choice, because one of the principles in the Artemis Accord says that space mining is lawful under the Outer Space Treaty. That is how we interpret the Outer Space Treaty. And so Australia, which has signed the Moon Agreement, which says no entity can own any part of the moon, also decided, because it wanted to be part of the Artemis program, to agree to this interpretation of the Outer Space Treaty. So we are stuck between a moon rock and a hard place, perhaps, into how we're going to interpret these two provisions. The Australian government has said it reads them in harmony, but I do think we're obliged to trigger that obligation to set up some kind of international regime. The key provisions there's a lot of great things in there about transparency, interoperability, encouraging states to register their activities, and to share scientific data. There is a very important principle that says that they will preserve outer space heritage. For example, the first footprints on the moon, any artifacts from early lunar exploration in those early programs, and including more recent ones from states which have attempted, such as Israel. And that space resources, space mining is lawful and also a concern for orbital debris around the moon. And we have enormous problems of space debris around Earth, and we're going to start to see the generation of debris around the moon. So it's an excellent thing that there's also a principle including taking responsible for debris mitigation planning, and that the states that create that debris have to remain responsible. So some tensions, I was going to say a little bit more about some non-binding principles, but I see my time is up, and Alice did mention some of those. So I guess the point is that there is quite a bit of international law and domestic law, but we're seeing it, we're seeing tensions around it as those activities are going to start to take place in the very near future.
Mm. Oh, Cassandra, thank you so much. There's already some questions coming in, and we will come back to them when we have heard from all of our speakers. I personally have some questions about the status of the Artemis Accords and this relationship between nation states being responsible for corporations and how the heck that's going to work. So we might come back to all of this, and there's a lot of great questions coming in. Thank you so much, Cassandra. We'll be inviting Cassandra to join us later in the year for our week of space exploration discussions, because I think we have a lot more to hear from in terms of what Cassandra's doing and her perspectives. So thank you very much, Cassandra, and we'll bring you back into the spotlight in a moment. Excuse me, now I'm getting a bit croaky as well. It's my great pleasure now to invite Eitan Tepper to join us. And for those who don't know, Eitan's done a vast amount of work, but one of the things that he did also do was write an article about should the moon have something like legal personhood the way New Zealand is using that construct for rivers and forests in its national laws. And it's Eitan's original work that triggered some of the early conversations that have led us to this group of people being interested in what's going to happen to the moon with all of these things. So Eitan, thank you so much for joining us, which is your yesterday. You're in the evening, aren't you?
Yes, I'm in the evening, and here it is still April 11. Thank you, Michelle, for the invitation. It's nice to see you, Alice. We met at the International Association for the Study of the Commons. Thank you, everyone. I have some slides that I will share with you. So this is kind of the outline of my talk, a bit of an introduction to what we call the New Zealand model, and then I will talk about economic analysis of the model and its possible application to the moon, to the resources, and even to habitats. So first, I would like to say that my talk is based on an article that I wrote together with my colleague and very good friend, Christopher Whitehead. At the time, we heard about the new act that was adopted in New Zealand, and it was, I thought it would be interesting to explore if this might be applied to the moon. Christopher Whitehead has a background as a New Zealand lawyer, and now he is a professor in New Zealand. So he is very well familiar with the New Zealand legal system. We also got some very good comments from Val Mentiki. She knows better than us indigenous perspective and philosophy, so that was very helpful. So the paper, I will not add much about what was said before about the race to go to the moon and to mine the space resources. I will also just remind what Cassandra was talking about, that the regulatory regime of it is unclear. There is the Outer Space Treaty, there was the Moon Agreement and the Artemis Accord. So it is unclear, or there is a debate about the legal regime. And here we wanted to explore the model of New Zealand. In our paper, we bring the history of New Zealand and its colonization. I don't have time to talk about it here. In 2014, the New Zealand adopted the Te Urewera Act. And this was very interesting because it was groundbreaking in the sense that it recognized the legal personality in the nature, which is not something that we are used to see in Western legal systems. This act applied to what was the Te Urewera National Park, which by the act was recognized to have legal personality. It is based on the Maori worldview that recognizes the concept of mana. It's a concept that has no direct Western equivalent. It can be seen as giving legal standing to any being possessed of it. And the Maori legal traditions sees mana and therefore standings in both human beings and the natural world. So the act did the main thing that the act did was first to recognize the legal personality of what was a national park, but also established an institution. It was incorporated as a kind of a common law corporation, and it had a board, and the act also provided the goals of the board and of the corporations that included the interests of the park and its protection, but also recognition the connection of the tribe, the historic connection of the tribe to the park. What we set out to do was to examine this very old philosophy using a very modern economic theory, and we got some interesting results. So we were using the theory of Elinor Ostrom. Elinor Ostrom was awarded the Nobel Prize for Economic Sciences in 2009. She was the first woman to be awarded of this prize. Her theory was about the management of the common pool resources. Generally, we can say that her conclusions was that decentralized local institutions perform better than their counterparts, and that the main objective of public policies should be to promote the development of these decentralized local institutions. She also identified 8 design principles for effective governance of the common pool resources. And we kind of set out to see if recognizing legal personality of natural park, the way it was done in New Zealand might meet those principles, because if it does, it might be an effective model. Generally, Ostrom found that users of common pool resources establish better rules that better fit the circumstances. And because it's the users who establish these rules, they tend to be followed more. But I want to talk now about does this model meet the design principle? So, and as I mentioned, there were 8 design principles. The first one was clear demarcation of boundaries in terms of the resource and of the users. And the New Zealand Act meets that because the Act defined clearly the territorial extent, and also it provides rules about the users. The second design principle is congruous with local conditions and regarding appropriation and provision. And also this rule, we found that the New Zealand Act meets that. Some activities require authorization, and such authorization we can expect that will be conditioned on meeting local conditions. The third design principle, collective choice arrangement, is only partially met. In terms of the law itself, it is an act of parliament that represents all New Zealanders and not just the tribe, but the board of the corporation is more, the Taura tribe is more represented there. Design principle number 4, monitoring users. This, we see that it applies, so does design principle 5. They are less important to us, so I will not talk much about them. Design principle 6, conflict resolution, also applies. Design principle 7 talks about minimal recognition of rights, which is that the rights of local users to make their own rules are recognized by the government. And here the Act itself represents recognition of the tribe, which is the primary user of the park, but also the rights of the park itself. Design principle 8, I think we can say, or our conclusion, that it also applies. So because we found that most of the design principles that Elinor Ostrom identified are met, we thought that the model that was presented in that Act might prove to be an efficient model. And then the question is, can we apply it to the moon? And here there are 2 ways to apply it. One is to the resources, and another one is to habitats. Applying this model to the moon as a whole, or to the resources, is it's possible. it is actually more closer to the original example of New Zealand. Applying it to space habitats is different because habitat is not a natural resource, but in some ways it is even more suitable to apply to habitat in terms of recognizing habitat as being a standalone. I would like to say that our project was a thought experiment. The New Zealand Act was new, and we didn't know at the time how it will work in practice, if it will prove to be a success or not. And our point in writing the article was not so much as to give a recommendation, but more like to open a discussion. And we are very happy that that others, including people here, joined the discussion and took it much further away than our early work. I think there is room to discuss it when we talk about a possible governance model for the moon. This should be discussed, and I'm happy that you are doing so. I can say just just some cautionary note that actually came by. We had now a visiting scholar at the Ostrom workshop, Julia Talbot Jonesa. I hope I'm pronouncing the name well. She's a professor from New Zealand, and she co-authored 2 papers about it, but generally she is examining how well this model actually works in practice. So this is something that I did not check, so I cannot tell about that. But this is something that we need to bear in mind to see how does it work, and if there are frictions, if there are things that needs improvement to improve the model. But in any case, I think we were very happy to see that very old philosophy can withstand the examination through the lens of a very contemporary economic analysis. And we're happy that you're all doing the work about the rights of the moon. So thank you, everybody. I think I stopped sharing.
Yes, you did. Thank you so much, Eitan. That was really excellent. And to bring us back really into conversation about the commons, as our other speakers have alluded, the idea that we're just progressing forward, and the Artemis Accords reflect this idea that, yes, mining is okay, use is okay, and yes, it's okay that the US should be first. All of these assumptions really need to be questioned. And I do find it interesting that there's this assumption within Ostrom's work herself, which is being reinterpreted, that local users are fine to make their own rules. And I actually saw in some articles responding to the Declaration for the Rights of the Moon that having such a declaration, bringing other people's in, was irrelevant and not useful. The best thing to do is just let all of the people who are in the space race make the rules themselves. And I find that very problematic personally, but we'll come back to some more questions in a moment. So Eitan, thank you so much. And I think your thought, it's really actually exciting to see that your article has triggered so many other discussions, including our own work. So I think it's so important to bring these new ideas into public spaces and into discussions. So thank you again for your work and your time in this space. And we'll now go to the wonderful Mari Margle. And we've asked Mari to speak about the Declaration for the Rights of the Moon that a number of us worked on together, to give to you a really alternative way of looking at what does it mean to care for the moon? How do we think about the moon itself? And we'll come back to some really important and complex issues after Mari's overview. So thank you so much, Mari.
Oh, thank you, Michelle. Thank you to everyone for being here. So just to say, the Declaration of the Rights of the Moon, which we're going to look at over the next few minutes, just in terms of the background, why we decided to put some time and thought and pen to paper, was building on Cassandra and Eitan's and Michelle and Alice's descriptions of what is being planned for the moon, the governance currently around it, and deep concerns about what happens when humankind colonizes a new place. And I mean new as if others haven't been there, whether human or non-human. Colonization of the moon is really what's being discussed now. And Michelle and Alice and I published an article recently specifically around this idea of colonization of the moon, and that came out of a proposal for time zones to be set for the moon, which is creating one of those key conditions for having a productive world up there on the moon. And so we had a lot of concerns about plans for the moon and this idea of exporting off Earth the exploitation and harm and extraction that colonization has brought and wrought around the world on Earth. And knowing that is the likely outcome unless we stop ourselves, we humans, before it happens. And the need essentially to look for a different way forward, much as Eitan was just describing, a shift in humans thinking, so that we don't create the kind of harm that we have seen and continue to experience here on Earth that's so devastating, not only to humankind, but to the natural world upon which we depend. So we drafted the declaration with those ideas in mind, that we need a new way forward, and building on the work to recognize legal rights of nature, which for those who are unfamiliar with that concept, just very quickly, recognizing legal rights of nature means recognized for the first time in binding law, in a constitution, in a court ruling, that nature itself possesses certain legal rights, including rights to exist, to regenerate, to evolve, to be restored if its rights are violated and it is harmed. Just these basic core rights that nature needs in order to be healthy and robust and resilient. And this is a very new area of law. The first rights of nature law was passed in 2006, so it hasn't been a long time that we've started to see law being innovated in this way. And it really comes out of deep concern for the overlapping environmental crises that we're experiencing right now on Earth. And so you have national laws like in Ecuador and in Bolivia, you have local laws in places like Brazil and Canada and the United States, you have court rulings in India and elsewhere, as well as laws that Eitan mentioned in New Zealand, recognizing legal personality for certain ecosystems. So this movement to recognize that nature itself possesses legal rights is growing. And so we drafted the declaration building on that idea that we need a fundamentally different relationship with nature, from one in which nature is treated as a resource or an item of commerce without legal rights, to a really fundamental shift in the law in which our relationship toward nature moves from one of control and one of domination and exploitation to one in which we put forth and foremost protection and respect for the natural world. And that's really what underpins the rights of nature laws. And so for the declaration itself, we've focused on what would that look like when we're thinking about the lunar natural environment. So I'm going to share my screen so that we can just review what the declaration actually says. And here we go. And this is on Michelle Ehlah's website. And we've done some webinars around the declaration as well, which I really encourage people to take a look at. So I'm just going to read through this and then we can chat with our questions and answers. And the other piece I should just mention is you'll see this box here, click to register your support. You can sign on essentially a petition in which you put your name saying, I support this declaration. And we would love for people to join us in that. So I'll just read through this. It's not very long. It says, we, the people of Earth, acknowledging the unique, intact, interconnected lunar environments and landscapes which exist on the moon, acknowledging the ancient primordial relationship between Earth and the moon, mindful of how much is still unknown about the co-origins of Earth and the moon, aware that the moon is critically important to the healthy functioning of the Earth system and is a vital sustaining component of all life on Earth, aware that the moon holds deep cultural and spiritual meaning for human beings, acknowledging that the cycles of the moon have enabled life itself to evolve on Earth. It goes on to say, mindful of the immeasurable value the moon holds as a repository of deep time and connection among all beings who have ever lived on Earth, since its features have remained almost unchanged since time immemorial. Conscious that wealthy nations and corporations are developing technologies that may make it possible to return to, live on, mine, and otherwise alter the moon. Aware of humanity's impact on the Earth, causing ecosystem collapse, a new era of mass species extinction, and global climate change, and seeking to avoid destruction and change to the natural systems in ecosystems of the moon. Declare that the moon, which consists of, but is not limited to, its surface and subsurface landscapes, including mountains and craters, rocks and boulders, regolith, dust, mantle, core, minerals, gases, water, ice, boundary exosphere, surrounding lunar orbits and cislunar space, is a sovereign natural entity in its own right, and in accordance with established international space law, no nation, entity, or individual of Earth may assert ownership or territorial sovereignty of the moon. And finally, this is the Declaration of Rights itself. The moon possesses fundamental rights which arise from its existence in the universe, including the right to exist, persist, and continue its vital cycles unaltered, unharmed, and unpolluted by human beings, the right to maintain ecological integrity, the right to be defined as a self-sustaining, intelligent, cohesive, intact lunar ecosystem beyond current human comprehension, the right to independently maintain its own life-sustaining relationship with the Earth's environments and living creatures, and the right to remain a forever peaceful celestial entity, unmarred by human conflict or warfare. We released the declaration in 2021. And as I've said, we've done a lot of outreach. We've asked people to sign on. It's generated a lot of discussion. And I will stop there, Michelle, to allow that discussion to take place here.
Excellent. Excuse me. Thank you so much, Mari, for reading through that document. And as we've said to people, it's, and as Eitan said about his article, it is first and foremost a provocation, a thought experiment to remind people that as we are sometimes in spaces where people assume their right to go and extract on the moon and do things to the moon, just as they have here on planet Earth, that declaration is to remind folks that that entity is much more mysterious and ancient and old and unknown than we could ever possibly imagine, and perhaps some caution and respect is actually required. So what I'm going to do now is bring our speakers back onto Spotlight so that you can all see each other. And I've grouped some of our questions together so that we can have a nice discussion around those issues. I think I have us all. There we are. So thanks so much again. This has been a really fascinating conversation, such wonderful speakers. I'm going to give a quick overview of the order in which we might talk about some of the questions so that we can all get a feel for, you know, when these issues are going to be discussed. First, I thought we might, and I'll come back with specific questions, we'll talk about the actual possible risks to the moon from a lot of these proposed activities. You know, is it valid to be concerned? Is there real risk? What does that risk look like, etc.? Then the next group of questions are really about how do we hold mining companies and others to account for things they do on the moon or on their way to the moon. Linked to that is my own question about how we have this relationship between corporations and nation states, given so many corporations are becoming more powerful than nation states. The regulatory structures are problematic. How do we make sure that everyone does the right thing? But then, of course, that all leads into one of the most fascinating areas, and some great stuff's popped up with Cassandra's discussion about Australia being a leader in this space. The third chunk of questions are, well, what's actually possible regarding an international regulatory body or space? Cassandra mentions that Australia could play a role, excuse me, as a space middle power, particularly one aspect, triggering the Moon Agreement's obligation to create a regulatory regime. And that could be a really hopeful way to step forward and to do more work as groups of people concerned. But let's start from the beginning. And thank you everyone for putting your questions and chats. I've collated them, as I said. And maybe, I don't know if Alice, you want to start, but everyone's welcome on our panel. What are the actual risks to the moon? If they're mining and they're digging holes, we know that regolith and moon dust is not like planet Earth. We've already had someone mentioned the problem of space junk circling planet Earth, let alone the moon as well. Someone asked, could it be knocked off orbit? And we've heard questions in previous webinars. If they keep digging holes in the moon, could they affect its density to such an extent that tidal activities and other things on planet Earth are disrupted forever? Alice, would you like to start? What could happen?
Well, the good news is that you would have to remove such a massive portion of the moon to affect its orbit and have an impact on the tides by lessening its gravitational pull, which that could be a very far future scenario, I guess, if we get to the point of dismantling planets in the solar system for human resources, as in the Kardashev scale, which I won't go into now, but there are people who have thought about this. So that part's good. Some of the other risks, though, are the moon is an extraordinary body. Because it has no atmosphere, it preserves the record of solar system events, changes. The whole evolution of the solar system is preserved on its surface in various chemical and mechanical signatures. And in a recent paper by the planetary scientist Ian Crawford, made the case that, in fact, the moon preserves early galactic history as well. As it's moved through different parts of the galaxy over billions of years, we have that record preserved in the regolith. So one of the risks is we'll destroy that. So if a justification of going to the moon is to increase our scientific knowledge and enable us to have a better understanding of how to sustainably live in the solar system, well, we risk destroying that. A feature, the moon is covered in this very fine dust, which does get transported, like there's a natural cycle of dust transport. But if we disrupt that, we also risk losing that scientific knowledge. The other risk to the moon is that we know it has water cycles. There's the ice lakes in the permanently shadowed regions, but water is being created and dissolved on a daily basis in all parts of the moon. We don't even understand this cycle properly. So again, we risk disrupting that before we fully understand it, and the precautionary principle comes into play here as well. So the moon's ecology and balance could change as a result of human activities. So we have to, I suppose part of what the declaration does is think of what this means for the moon itself as that cohesive, intact identity. But the other argument, which of course appeals to the space community, is that we're cutting off our nose to spite our face. We actually destroy the very scientific records that we're claiming we're out there to seek. So just a few of the possible impacts.
Thanks, Alice. Cassandra or anyone else, would you like to comment also on concerns about what might happen to the moon and us?
Yeah, so my biggest concern is lunar orbital debris. I mean, I think really that there are a lot of very smart scientists thinking about what the physical impacts might be. And as Alice said, it would have to be, of a scale beyond certainly comprehension for the next several decades. Like if we're going to impact tides, it's going to be something like absolutely massive that is probably unlikely, because then you can't continue to extract the resources that you need. So there will be some limiting factor to that, I think, if we're keeping it realistic. My concern is the nearer term impacts, as in what we're going to see even in the next decade. So currently in orbit around Earth, we have about 6,500 operational satellites, and we have estimated 130 million pieces of debris, and that's anything from a giant defunct satellite up in the further orbits, 36,000 kilometers and further out. Some of those are sitting in what's called graveyard orbits, so they've run out of fuel, they've ceased to function, and they just get pushed out into a slightly further orbit to get out of the way of the functional orbits that need to be used. So we've kind of created a junkyard. And then so it could be these big defunct satellites, or it could be down to something that is a centimeter or smaller, that's fragmentation debris by things either deliberately destroyed by these anti-satellite weapons tests or accidental collision, because we just have an enormous amount of space traffic that we're just contributing to at the moment every few weeks with more and more launches, without having figured out how to deal with the debris problem and the space traffic problem. We need to be removing stuff from the orbits. But the rate at which we're putting more things into them is problematic. And there is some, in particular, I'm a huge fan of Moriba Jah's work. J-A-H is his surname. He's a space environmentalist, he's an astrophysicist, and he brings the science to the environmentalism. And he talks about the carrying capacity of these orbits that we depend on. We use space-based technologies every single day, hundreds of times a day. We are critically dependent on it, and yet we're filling up, these orbits we depend on are becoming saturated with traffic and debris. So we're already doing that. And now we're about to move our activities to the moon. And it's a little bit, for a lot of people, hard to get their heads around why and what it means. And well, that's why we're talking about this today. But if you think about the general public, it all sounds a bit like science fiction, and, it'll be robots and it'll be astronauts, and that's all very cool. But there's very little comprehension of the amount of lunar traffic we're going to create, and therefore lunar debris. Some of it is routine. Some of it's bits that need to break off in order for a spacecraft to continue to do its job. Some of it might be collisions. Part of the Artemis program is to create a permanent lunar space station, the gateway. Because it's geopolitical, you've got China and Russia doing their programs, Japan doing its program, Israel is keen to do smaller programs. The United Arab Emirates is keen to be the first Arabic country with lunar programs. So it's going to be both commercial and geopolitical. And we don't have anything in place other than these very soft debris mitigation requirements, which say, build into the design of your spacecraft or your satellite what you're going to do with it at the end of its life. But that's kind of not enough at this stage. So my biggest concern are about the orbits and the cislunar space, so between the Earth and the Moon, because we're going to continue to be dependent on that for our terrestrial needs. Need is going to increase as our technologies increase. And if we're thinking about intergenerational equity, so that future generations' ability to also keep being able to use space for these technological needs on Earth. Like, I'm not even thinking about going to the Moon or Mars for exploration purposes. I'm thinking about us on Earth. So I have a huge concern about that aspect of the impacts of our activities.
Wow, the list goes on. And look, I know that anyone listening today will also be asking many other questions. And I promise that in future webinars, we'll discuss them in more detail. But I think that is a nice snapshot. Regolith fine dust. We're not sure what's going to happen once they start digging holes. And then there's all this debris. And let's face it, anyone who sort of pushes those concerns aside, we only have to suggest, hang on, let's look at what we've done on planet Earth in terms of let's just do whatever we want and then we'll think about cleaning it up later. And the idea of cleaning it up later in space, maybe we'll never have the technology to do that. These are things that the precautionary principle would have been kind of lovely if people took seriously, like, hey, if you can't fix it, maybe don't do it. Anyway, so there's lots of issues, lots of concerns. Good news is that have to be mining for a very long time to actually, say, take out half the mass of the moon and then destroy the entire world as we know it. Hopefully that's good news, but I don't have a lot of faith in extractivism industries to do the right thing at any point. So we have a potential list of many concerns and problems. So the next questions, they will bleed together, really. Who will hold and who is holding companies responsible and to account now for that space debris? Is anyone being ordered to clean stuff up? And then that links to what's possible with a different regulatory system into the future. And then that will loop us back to the final question, which I am going to put to you all: should the moon have its own legal rights at the end? So questions are, how do we hold any space exploration companies now to account for the debris they leave out there? And what could we possibly do to hold anyone to account for action on the moon? I might turn to the lawyers in the group. I don't know, Cassandra, if you'd like to start, or if Eitan, if you've got thoughts on this.
I do have some thoughts, or initial thoughts, about the corporations and the outer space. I'm actually organizing a workshop next month in Canada about the governance of the space exploration corporations. And the title of the workshop begins with corporate sovereigns, and the idea there, and it is also relevant when we talk about companies and the space debris, but more so if we're talking about companies establishing moon habitats or habitats on Mars. If we look back at the history, we have the case of the East India Company, which was a hybrid of a company and a state. On the one hand, it was a company, it was doing business, and for a long time, it was actually doing very good business. Of course, it was exploiting indigenous people and their resources. But on the other hand, this company was behaving like a sovereign state. It had its own army that was at its height twice as large as the British Army. It had a port system, all the administration. It was signing an international treaty, and the record of this company and equivalent company is very problematic. And we can see some signs even today when we talk about the big tech. And what we are trying in this workshop to think is what happens when you have companies that are exercising powers that are normally associated with sovereign states. And we're trying to think maybe we should introduce some checks and balances that applies to sovereign states, but do not apply now to corporations because we see them only as private entities. So it is a good question that I think that we should think more about, and what I'm trying to do. Answers, there can be all sorts of answers. Generally, I think that we need to think of when a corporation acts like a sovereign state, it should have some checks and balances on these activities.
Thank you, Eitan. Cassandra.
Yeah, so I guess that historical example is so important, because that is how the seas were dominated and trade was dominated and how empires were created. And I think when people say today, well, commercial entities are just doing whatever they want, I think we have to realize they are enabled by the state under whose jurisdiction they fall to do those things. They can't just go into it. Have to abide by whatever corporate governance laws there are, and insurance laws and labor laws, and whatever permits they have to seek to mine or to whatever activity it is. And I guess mining is the analogy here, because that's what it's a mining industry that's going to develop on the moon. They always have to adhere to layers and layers of domestic jurisdiction, and sometimes to international laws, because the state under whose jurisdiction they fall is obliged to adhere to those rules. So that is why I think the Outer Space Treaty has that genius principle, which says the state remains responsible under international law. When something goes wrong, it is the state who is responsible. And then if they are brought to court or held responsible, or there are reparations sought by a state that is injured, well, that state will then go back to the commercial entity to recover. And also it's obliged to authorize and continually supervise those activities. The problem is, what does it mean to authorize and continually supervise? It's up to the state to interpret what that means and what its own laws have to look like. So at the moment, you know, the US has more domestic space law than any other country, but most of those laws have been driven by the commercial entities who lobby and sometimes draft the laws. And because the prime directive for the US is to have commercial and political dominance in the space, the global space sector. So not necessarily physically in space, but in the commercial space sector and also militarily. And so it is more driven by competitive interest than it is by sustainability, for example. There is a bit of a pushback from the UN long-term sustainability guidelines, 21 guidelines, which are non-binding, which again, the onus is on the states to do something about debris mitigation and sustainability, cultivating a culture of sustainability. That is one of the guidelines. But what we're seeing is a really positive trend towards states wanting to prove what great space citizens they are. So the UK is the world's lead space diplomat. It is in terms of space arms control, and it certainly is in terms of sustainability. It was the first country to come up with a reporting system for the long-term sustainability guidelines and to table at the UN, this is how we are implementing each of those guidelines. Here's a template. We call on all countries to do the same. And our Australian Space Agency has been really looking at how it can also try and become one of the first countries to implement all 21 of the guidelines and how it's going to do that. And one of the things it has to do is require its commercial space industry to be implementing sustainability practices and sustainability culture as part of its commercial culture. You know, commercial entities depend on the sustainability of the space domain when we're talking about debris because their business models require continued access to space. And the same thing can be said of what's going to happen on the moon. So although it's commercially driven and although it's hyper-capitalist, as Alice said, and although it's also geopolitical, which brings a whole bunch of concerns with it, there are some limiting factors in that if these companies want to continue to have a business model, they need to ensure that there is some sustainability to it. And I do think that there is a push now that space is accessible to more and more countries and companies, and not just the greater powers and the kind of, you know, traditional multinationals. Over 80 countries have space programs. There's not a single country which is not dependent on space in some way. And I think that awareness is going to grow once these activities on the moon start to actually take place in the next 5 years or so. So there is a bit of a positive trend towards how we're going to do this sustainably. And implementing domestic laws, you know, there is a risk still that a company might say what they do, what's called in the law of the sea, a flag of convenience. So if a company wants to be doing some trading or some fishing and it isn't given a permit in the country where it was normally established, it will go and establish itself in another country which has perhaps, you know, a lighter touch on those kind of laws and carry the flag of that nation, and suddenly it can do things that it couldn't before. So there's always a bit of a risk around that. You know, I have to remain optimistic, otherwise I can't keep doing the line of work that I do. But I do think ATON's actually done some amazing work around polycentric governance. So there's lots of different kinds of governance and rules and best practices that are emerging in lots of different ways around the world. It doesn't just have to come from the UN, and it doesn't just have to come from domestic legislation. It can also come from the private sector coming up with best practices for itself. And in fact, there are some really great examples of that because their technologies are moving faster than government regulations are, and they're seeing the need for some kind of sustainability balances and measures. So, you know, yes, there's the kind of the evil dystopian version of what could happen, but I do think that there are some positive pressures as well. You know, the concern for climate change translates directly to what's going on.
Yeah, but I do think that in theory, there are a lot of different models that could happen. And in theory, certain companies should do the right thing because it's in their best interest. But you might say that about certain extractivist activities on planet Earth as well, that in theory, they have these, you know, greenwashed versions of sustainability, but in practice, what they're doing is continuing to devastate places and people. So I think people's genuine concern about the longer term governance over space exploration, I think the cynicism is justified because we are at such a critical point in humanity's history on planet Earth. But I don't mean to be negative. I do hope that those positive aspects for the next phase of governance are embraced. Alice, you've had your hand up for a little while. So polite. And you're on mute, Dal, just to remind you.
As I was thinking, listening to Eitan and Cassandra talk, there's a lot of great work being done on how you might have an environmental impact regime for the moon and other bodies in space. which again is cause for hope. But I just thought I would relate an anecdote of sitting in a meeting where we were crafting some text about environmental impact assessment in space, and a US delegate at this meeting objected to the words environmental and impact and assessment appearing next to each other in a sentence, because they said the US would not like that. And I was rather gobsmacked, but I suspect that reflects the realities as Cassandra has outlined them.
And it also comes back, doesn't it, to, I think it was your comments early on, Alice, that the moon is seen not as something alive. And that is a great concern to many of us, because it feels like if corporations think that they can go to a place where there's no people and there's no life, then it doesn't really matter. That's not going to encourage a healthy attitude to looking after the ecosystem. Mari, did you have anything to add on the governance or any of these issues? Or we might go back to this idea of triggering the Moon Agreement's obligation, which is an exciting thing to end on. I think we're officially out of time, but I thought a couple more minutes on that issue could be great. But Mari, did you have anything to add on the governance?
No, Michelle, let's segue to that.
Yeah, thank you. Okay, so I was really encouraged, Cassandra, by your mention of this possibility of triggering the obligation that's embedded in the Moon Agreement to create a proper, fully established regulatory regime rather than just make things up as companies progress further. Are you able to speak a little bit more to that? Like, what would have to happen, or how many nation states would have to do something, and can we as ordinary humans here in Australia, particularly, but I know folks are from other places, play a positive role in writing to people and saying, let's do this, trigger this thing, make the world a better place?
Yeah, absolutely. States, governments will do what they think people want, what's going to get them re-elected, right? So if this becomes an issue that we tie into Australia's potential for middle power leadership, we have a history of norm entrepreneurship, a very proud history of international rules-based order and what role we play in that. We are one of the few countries in the world that has signed all 5 of the core space treaties, because there are so few who've signed the Moon Agreement. And we're in this amazing position. The US has literally stated that it sees Australia as the pot of gold at the end of the rainbow when it comes to space activities. I abhor that statement, because we shouldn't just be looking at ourselves as a supply chain into NASA or into Space Force. There are amazing things Australia can do as a nation in the space sector. It can contribute really important things like, space situation awareness to deal with space debris and communications technology. But because the US sees us that way, we can leverage that. We are also seen generally as one of the balanced, stable, and kind of good middle powers like Canada, like the UK. More so than France, for instance, like Japan, and now like South Korea, which are very important space partners for us as well. There's a huge opportunity for us to say, actually, we're going to take a stance on this. We have a legal obligation that unless we withdraw from the Moon Agreement, which would be a massive political statement, we are obliged to trigger that article at some point. And in fact, the Moon Agreement is a much better agreement than many states who criticize it think it is. In fact, there's a lot in there which is exactly what's in the Artemis Accords, and sometimes it says it better than the Artemis Accords, even in the sense that the Artemis Accords authors have wanted to say. The key piece that the US disagrees with and wants no part in is that benefit sharing aspect, that if certain countries or companies benefit from the extraction of resources, there has to be some kind of benefit sharing. That is not actually written into what the regime should look like. It's just that the Moon Agreement does say there should be equitable access and the common heritage of mankind. But even the common heritage of mankind does not necessarily mean that there has to be a financial benefit sharing regime, as was attempted with the Deep Seabed Authority. That's one model. Some countries argue that's the only model. Some countries argue that that's the only thing that common heritage of mankind means. So what Australia could do is say, look, we can come up with a new regime which fulfills everything that we are obliged to adhere to under the Moon Agreement, but also kind of does what the Artemis Accords is trying to do. Because I have to say, I've resigned myself to the fact that space mining is going to happen. I've just resigned myself to it. It's a fait accompli, I think. So how do we go about regulating and governing it in a responsible way? Then I do think there's an opportunity for Australia. What we lack, though, is lack of sufficient space literacy across our government. Our government doesn't understand why any of this is important beyond astronauts and rockets and moon to Mars, which is a kind of futuristic thing when they are trying to deal with climate change, a cost of living crisis, housing crisis, and issues around the Indigenous voice to government. So what we need to teach our government is why these space technologies are actually critical to solving all of those issues. And that is why we need to be taking a role in the cutting edge stuff, because if we can be taken seriously as a space middle power around that and around other issues we're committed to, that's where we get to have impact. It's not, it's great we're going to have an Australian astronaut who's currently being trained, but it's not just about astronauts.
Thank you, Cassandra. And Alice has written in the comments, yes, to everything you just said. So I'm going to circle back now. Eitan, do you think if the moon had its own legal rights, it would have greater protection in this future regime that's starting to happen? Or do you see other governance options more effective? And you're on mute, just a reminder, everyone.
I did not follow the results of the implementation of the New Zealand Act, so I cannot say if it was working good, if the results were better from how it was before. I can say that the ramifications could be wider. We're actually right now working on a joint paper at the Ostrom workshop, considering the relationship between alternative property right regimes and the chances for open conflict or even armed conflict. And if we reflect back on the history of colonization, when countries discovered new territories and resources, it led more than once to wars over these resources. So I think we need to come up with a good regime that will be sustainable, but also reduce the risk for conflict.
Thank you, Eitan. Mari, what do you think from everything you've heard and what we've been looking at over this last few years?
Yes, I think the quick answer, Michelle, is yes. Recognizing that the moon possesses legal rights, essentially to be free from human interference with the ecosystems and life cycles and so on within the lunar ecosystem. And very importantly, as part of that, is how do we enforce that? And this is a question that gets back a little bit to one of your earlier questions a few moments ago, but essentially, how do we hold each other to account on that? And that requires a really robust agreement by the international community that they are going to be willing to hold each other accountable. And unfortunately, we have pretty poor models right now around this, and climate change. I think Cassandra just mentioned that, something that's so many governments are so focused on for all of the reasons we know they should be. But one of the problems that we have is that our climate change UN protocols provide very little capacity to enforce or to hold other nations accountable for their climate change activities. And so that's a real failure from my perspective about climate change policy on the international level, which I would very much want to make a far more robust if it comes to enforcing protections and rights for the moon.
Thank you, Mari. Very thoughtful. And finally, over to you, Alice. What do you think about if the moon had its own legal rights? Would that help the moon? Oh, you're on mute again. Yep.
No, I'm unmuted. I just wanted to check. We're nearly out of time, aren't we?
We're out of time, but 2 more minutes and then we'll wrap up. We're over time even.
Yeah, I mean, I really think we need different perspectives, and we need a much broader definition of what law is that incorporates non-European derived systems of law. And I think if we gave the moon some legal rights, it would absolutely relate to that issue of accountability. And of course, people say, but the moon can't speak, the moon has no voice, so how is it going to represent its opinions? So obviously it would need to be a bunch of humans who would be representing those opinions. We can't get away from that. We can't step outside ourselves and become not human. But I don't see that as a problem. So the minute you have to be in something else's shoes or something else's orbit and attempt to put yourself into that perspective, you have to develop different approaches. So even though we're limited by that, we don't have to be absolutely limited by that. So I think there is a lot of power in attempting to think from the perspective of the moon.
I think that's a perfect way to end it. Alice, you did have something you wanted to mention about the kids' response to the Declaration for the Rights of the Moon. Do you want to just quickly tell us that? And then we'll jump in.
Super quickly, just to finish, I think a source for hope is the younger generations. We have seen to be incredibly politically savvy and politically active. In 2021, I ran a workshop with some school kids in a tiny country town in Australia, and they crafted their own Declaration of the Rights of the Moon. This included 2 rights: the right to be beautiful and the right to shine.
Oh, that is beautiful. Alice, we have to put that up on our website. That would be wonderful.
Absolutely.
Yeah.
Let's do it.
The right to be beautiful and the right to shine. I think we all deserve that right. And certainly the moon does too. But look, thank you so much to all of our speakers and to everyone who's joined us live today. This recording will be up on the website early next week, and I know we'll get a lot more views. But Cassandra, Eitan, Alice and Mari, thank you so much for this fascinating conversation. So important. And I look forward to many more into the future. And thank you, everybody. Lots of lovely comments coming in. Thanks, everyone. Amazing. People have really enjoyed the discussion. Thank you for your time, and have a great morning, afternoon, or evening.
Thank you.
A great Uranus night.
Yes, thank you. Thanks, guys.
Thank you, everybody.
Thank you.